Hello, I'm attorney Justin M. Kennedy with Litherland Kennedy and Associates, an estate planning and elder care law firm. Today's topic is California's Proposition 19, which went into effect February 2021. This proposition imposed severe restrictions on the parent-child exclusion. In order to fully understand this topic, it is best to go through a brief analysis regarding property taxes. You see, there's a considerable difference between the fair market value of a property and its assessed value. The fair market value is the price that a buyer is willing to pay for your home on the open market. The price that was paid by a buyer becomes that buyer's new assessed value. Proposition 13 limits the increase of this assessed value to no more than 2% increase each year. Generally, a property's fair market value will appreciate much faster than 2% a year. Now, let's take a look at an example. 40 years ago, you purchased your home for $80,000. Today, that property has a market value of $2 million, yet the assessed value may have only increased to $200,000 thanks to Proposition 13's limit on annual increases. This benefit of Proposition 13 is still current even after Proposition 19's passage. To understand what Proposition 19 took away, it is important for you to know that we had almost 40 years of California law prior to the passage of Prop 19, where you were able to pass along your low property tax assessed value and the corresponding low property tax bill to your children, thanks to Proposition 58. There was also Proposition 193 that allowed for a grandparent to grandchild exception. The way these propositions worked is that you could transfer to your children your home with no value restrictions, plus an additional properties with up to $1 million of assessed value. And remember, assessed value may be considerably lower than the fair market value. Families could pass family cabins, rental properties, and other properties down through the generations while preserving that much lower property tax bill. Let's return to our example of a $2 million property that you bought many years ago, so it only has an assessed value of $200,000. When you pay property taxes, that tax bill is calculated on that $200,000 value. Upon your death or when you transfer that property, it will be reassessed, and the property tax bill going forward will be based upon that $2 million fair market value unless an exception applies. Under Proposition 19, there is one exception to this $2 million reassessment. The property must pass a three-part test. Part 1, the property must have been the parent's primary residence. Part 2, within 1 year of the death or transfer, a child must claim the property as that child's primary residence on Form BOE 19 and file a homeowner exemption form. Part 3, then the county only ignores the first $1 million of appreciation above the assessed value, and the difference will be reassessed and added to the existing assessed value to create a new assessed value going forward. That $1 million of disregarded appreciation is indexed for inflation. Last year, the adjusted amount was $1,022,600. And until February 2027, the current adjusted amount is $1,044,586. Let's once again return to our $2 million property with a $200,000 assessed value. Assuming the property satisfies all three parts of the Proposition 19 analysis, the new property tax assessed value would jump to $955,414. While an assessed value of less than $1 million is still better than a $2 million complete reassessment, unfortunately, this child would receive property tax bills that are thousands of dollars more expensive each year than their parents' prior tax bill. As mentioned above, this parent-child transfer exclusion only applies to the home. So any other property, think rentals, vacation properties, family cabins, etc., will all be reassessed. Before you start to think that Proposition 19 is only bad, there is a good aspect. If you are 55 or older, disabled, or a victim of fire or natural disaster, you can now move your primary residence up to 3 times anywhere in the state of California and maintain your low property tax assessed basis. If the replacement property is purchased for the same value or less from the prior property, then the property tax bill remains the same. If you buy a more expensive property, then the excess in value would be reassessed. Let's see an example of this. If you sell your $2 million home with an assessed value of $200,000 and buy a new home for $2 million or less, then you get to keep that same $200,000 assessed value. Alternatively, if the replacement property was $2.3 million, then that extra $300,000 would be added to your $200,000 existing assessed value for a new assessed value of $500,000 for this $2.3 million replacement home. Upon a death, or when you are thinking about transferring a property, we recommend that you contact an experienced estate planning attorney to help you to determine your next steps and review the tax consequences. There may be important tax and/or legal actions that need to be timely made. Thank you.